All right, my name is Shapiro. I'm a VA attorney, and I want to start a video series where I'm answering veterans' questions that I find online. Hopefully, you'll find this helpful. Right now, I'm on Reddit, and I see 5 hours ago on December 17th, 2025, post by Idiot Vet, is what it is. He's posted his decision letter from his higher level review. He's basically saying, I need help with my HLR denial, which stands for your higher level review. And it's regarding the issue of service connection for post-traumatic stress disorder with alcohol use disorder, severe, active, claimed as anxiety disorder. So I just want to kind of show you guys how to look at this really quickly, because the VA is not a good communicator. They're just not. So they're going to send you a decision letter, and it's going to have all these boilerplate laws. It's going to have copy and paste from different VA examinations. And it's just going to be a nightmare to kind of go through. So look, just in the AMA system, which became effective in 2019, I think February of 2019, AMA is the Appeals Modernization Act. The VA has to list out favorable findings. Favorable findings are things that you don't need to reprove in your case. And generally speaking, for all service connection claims, you need to prove three things. All right, it's your current disability, it's an in-service event, and it's a nexus between the current disability and the in-service event. You have to prove those things. The favorable findings lend to whether or not you satisfied one of those three buckets. All right. So looking at this veteran's decision letter, it looks like under the favorable findings section, this is on page 3 of what he posted, it says, you have been diagnosed with a disability. Great. That's bucket number 1. They say that you have been diagnosed with post-traumatic stress disorder with alcohol use disorder, severe and active. This is oftentimes the hardest element to overcome. If you don't have a disability, the VA is not going to pay you. Even if you suffered from an in-service event or you experienced an in-service event, even if you're saying that there's definitely a nexus between it, you have to have a disability. You got to go to a doctor. Most of the time, there's ways to argue that, but easiest way is just go to a doctor in the appropriate specialty, get a diagnosis, submit that to the VA. And just as a side note, if you've ever filed a claim and the VA hasn't arranged a VA examination called a compensation and pension exam, it's probably because you didn't jump over that first hurdle, that first bucket. You didn't show them that you have a current disability. They're not going to expend resources to assess a nexus if you don't show that you're currently having a disability. So that's great. So this veteran checked off that element. We also see, and there's a lot of other favorable findings here, basically lending to that same element. There's another sentence here that says you've been diagnosed with a disability at Central Alabama VA Medical Center. Great. Other good news here is that the evidence shows that you performed service in Southwest Asia. You have verified service in Afghanistan. This is kind of lending to an in-service event, but yeah, okay, so the VA is also saying evidence shows a qualifying event, injury, or disease had its onset during service. There's a record dated August 2016, noted treatment for anxiety. This is great. So you filled that second bucket, okay? You've checked off current diagnosis, in-service event. You don't need to reprove it, okay? But the issue is the nexus, and I think there was a commenter in the Reddit post that said exactly that. Look, you need a nexus, and I couldn't agree more. The troubling thing is that there looks like there's two different opinions copied and pasted into this decision letter. One says the claim condition was less likely than not, and down at the bottom of page 2 it says the claim condition was at least as likely as not. I'm looking at my camera's in the way. So a couple things here to understand is this is contradictory, of course. Typically in VA claims, all this has gone through some morphing over time. You need an approximate balance of positive, favorable, and negative evidence to get granted. There's a statute, I think it's, don't quote me on this, 5107B. I'll have to look that up, but it's basically the benefit of the doubt And so if there's an approximate balance of favorable and unfavorable evidence, the benefit of the doubt should go to the veteran. There's also a regulation that talks about reasonable doubt. So if there's reasonable doubt that for any kind of fact, reasonable doubt must be resolved in the veteran's favor. So here, the things that are coming up in my mind already is if there's an exam that says yes, an exam that says no, reasonable doubt likely should have been resolved in the veteran's favor. The problem is that this veteran is post a higher level review. Okay, and so a higher level review is what you file to speak with a decision review officer, a more senior examiner who didn't make the first decision and is supposed to take a look at your claim and find out any errors. The veteran did this. In other words, he received an initial denial. He filed a higher level review. The higher level review came back denial. You can't submit any evidence for a higher level review, and you can't higher level review a higher level review. So what are those veterans' options? You have to go to the board, or you have to file a supplemental claim with the VA and submit new evidence. You probably could file to the board what's called a direct docket appeal, and just argue the legal technicality here of the reasonable doubt, benefit of the doubt. But because the board has longer wait times, that's a lot of risk to file to the board and just hinge it on that. Now, without looking into this veteran's specific claims file, I'm speaking generally here. There could be a lot of evidence actually in favor of a grant, and maybe it makes sense to do the direct docket to the board, have a faster decision, which is the fastest lane. But typically, what I would want to do is just get the final say, get a reasonable nexus letter from an actual provider who's good at what they do, who's going to explain why the negative VA examination was lackluster, was lackadaisical, was poor, reasoned. There's a whole list of ways to combat a negative VA examination. Link up with an attorney or an advocate if you want to explore that in more detail. But you probably want an nexus opinion from a doctor who's going to refute that negative opinion, bolster the fact that your in-service event, which is conceded, your current diagnosis, which is conceded by the VA, has a nexus. Okay. And another thing I want to just really stress for veterans is, look, you can win the battle, lose the war. All right. Sometimes you think, I just need to submit a nexus, but you want to be thinking ahead. The VA oftentimes will grant connection based on the date of your evidence that you submitted. Okay, they're not supposed to do this. This is an appeal I do. One of the most common appeals I do is effective dates. All right, when you're getting evidence, you want to make sure that the examiner is also pinpointing a date when the severity occurred, when the diagnosis manifested, or when the condition manifested, and you want to supply the VA, the board, the agency, evidence of your severity and the timeline as well, not just the nexus. Because what a shame it would be to get service connection for what looks like a severe mental health condition, PTSD noted as severe, and you file it and the board answers it in, like, let's just say a year from now, okay, and you've already been going for about a year, and then answers this, grants the claim, but the effective date when VA implements it is a year from now. Let's say a year from now the VA implements the board's grant, if you go to the board, and then the VA grants it from December of 2026. It's like working for 2 years and then not getting paid. So just something to think about. I hope that was helpful.